Hey, good afternoon, everybody. Thank you for joining us for What's Up With Us, the real property law section monthly, I don't know, webinar from the California Association of Realtors featuring me, Neil Kalin, and Michael Simpson, my co-host. So thank
Simkin.
Simkin, sorry about that. So thanks for joining us. We've got a bunch of cases today we're going to talk about, so let's just jump right into it. We also have a guest that we're going to be interviewing who is going to help us with our analyses of these various cases today. So
Well, I'm
let's kind of,
excited. I'm excited to have our guest because I think he's one of the most knowledgeable legal minds that I've ever experienced through the real property law section by reading his block journal, his little notes that he sends out.
Thank you,
and,
Michael. That's very kind of you.
and I almost feel, Monty, in a way that I know you because with the real property section e-news, there's always a blurb from you every
Right.
month. So yeah, so I get to know you as well, and now in person. So this is great. Let's see. So what are we talking about today? Well, we're going to be talking about a California Supreme Court case, another Planet v. Vigilant, where we finally get a a definitive answer on all those COVID cases from the last couple of years. Then we've got another insurance case, this case dealing with an interpretation of some language that, lo and behold, hasn't been interpreted before. So kind of interesting there for that scenario once we get into it. We'll have our interview with Monty, then talking about, we've seen a lot of cases over the last few years with parties getting injured and the government claiming immunity. So this is another one of those cases. And then Simple Avo versus Southern California Edison that dealt with one of the wildfires of the last few years, and there was a couple of interesting issues in this case. I really focused I really focused on whether whether parties can stipulate to a judgment and have that be appealable. There was also, though, a substantive issue involved in the case. I don't know. Michael always tends to like kind of go off and address all these other issues. So maybe we'll talk about that one as well. And then I see I forgot to update my agenda. There was a case that I thought was an interesting case. It was a trial court case, and there was just recently an announcement that this case is being appealed. And so I thought I would just bring that to everybody's attention and then ask our audience, maybe you are aware of some trial court case that is being appealed. We don't have the case yet, but just something that, real property practitioners might want to keep their eyes open for coming up in the future. So let's see. I have my little friendly way to get us started. It's June. So I got a couple of quotes here about June, but basically, June's what? June is summer, right? And I really love this from Jean-Paul Sartre, maybe. To read a poem in January is as lovely as to go for a walk in June. I like that. So we're going to get our summer started by talking about another planet versus vigilant insurance. Michael, you're kind of giving this look. Do you have
That's what I
something
was
to say
thinking
about
about.
that
Okay,
one?
I'll tell you what I was thinking about. This was in the news like last week. It's like you're looking forward to the summer and the days are getting longer and you're so excited about all that. But guess what? On that summer solstice date, is that June 20th, whatever it was?
June
That's the
20th.
that's the longest day of the year. So we're now in the waning period. Now it's like
Right.
negative. It's like
True.
everything is getting shorter and shorter.
Well, I like that date because I start thinking I live in the San Fernando Valley in Los Angeles, and then as the days get shorter, I'm able to take my dog out a little bit earlier without baking myself and him as we're going for our walk. He is a Bernedoodle. I guess they've got like a double coat of fur. So, we got to wait till the sun goes down before we take our walks. So it's nice. I know it's coming. It's coming. I don't have to wait till 8 p.m. to go for a walk with my dog. So that being said, let's jump into the California Supreme Court. Another Planet v. Vigilant Insurance. What happened here? Well, another Planet is an entertainment venue operator, and they have locations in California. They have locations in Nevada. I think they have locations elsewhere. And then, of course, like everybody else, practically everybody else, they were forced to shut down their businesses. They filed a claim for insurance with Vigilant Insurance. And, Vigilant denied, right? The insurance companies throughout the nation were denying these claims. Planet then brought a suit in federal district court. So what happened? Federal district court, Northern District of California. Vigilant brought a motion to dismiss. The district court said, yeah, we'll grant your motion to dismiss. Planet appealed. It went up to the Ninth Circuit Court of Appeals. And the Ninth Circuit, I guess, didn't want to answer the question, or felt that they could not answer the question because there was really a lack of clarity in California law, because appellate cases in California went both ways on this issue. And we'll talk a little bit more about it. But the wording that seemed to be consistent with all of these different cases, whether they're looking for business interruption or whether they're looking for actual damages or loss of income, whatever it was, certain language seemed to be so common in all of these policies that only required the insurance company, right, to step in if there was direct physical loss or damage to property. And we're talking about what? A commercial property insurance policy. So the Ninth Circuit, not knowing how California would answer this question for what was really involved California properties and California parties, said, we're going to ask the California Supreme Court to address this issue. And the California Supreme Court said, yes, we're going to accept this case, which means they're going to come down with a decision. They're going to look at the competing appellate decisions that are out there in the marketplace, and they're going to come to a conclusion. And what did the appellate court decide? Well, the appellate court decided, allegations of the actual or potential presence of COVID-19 on an insured premises, and this is really clear, do not without more establish a direct physical loss or damage to property within the meaning of these types of insurance policies. Okay. There has to be something more. There has to be distinct, demonstrable physical alteration to the property. It doesn't have to be visible. They give lots of examples where maybe there's a smell or there's an odor because of smoke damage, for example. Okay. But it must result in some type of injury to or impairment of the property as property, not the property the way it's intended to be used, but the property itself, the physical property itself. Okay? So another Planet, made these allegations. Well, the virus bonds with the property. It interacts on a microscopic level, with whatever. They have entertainment venues with the chairs, with the seats, that people would come and sit in, right? And then the issue, the California Supreme Court says, well, but what are you talking about? Well, you're talking about what is the injury? The injury is not to the property. The injury is that you cannot use your property. That's what you're claiming the injury was. Is it because of that? I've got I think on my next slide, I've got kind of a disgusting picture of chewed up gum, right? So is COVID-19 like sticking gum on a tabletop, right? Yeah, it bonds with the tabletop to some degree, but is that what's causing the damage? Is that what's giving rise to the claim here? I know, kind of crude, kind of simple for an explanation of that, but that's kind of how I think of this when I was looking at the cases and I was looking at the underlying cases, and we discussed several of these, Michael, over the last few years. We discussed several of these cases, right? And some of them were really tied, really perfect for you, Michael, because they were tied on, well, as long as you've made an allegation, that was sufficient, right? Because it depends on the pleading, and then let this all get resolved, at the trial court, level, or with the judge or with the jury. California Supreme Court said, we need some direction here, and this is the direction that they were going in. I don't know, Michael, what did you think? Did they make the right decision or the wrong decision?
It's the right decision. It's similar to what we've discussed before about this physical damage definitions or bodily injury. And this court went through like this long history and citation of other cases, like the Marina Pacific and everybody else. But there's still, hey, this is what people don't understand. This is my helpful litigation tip for the day. There are different types of judicial officers. Some of them erroneously think that the law is math or science, and it's, this statute says this, and these pieces seem to fit there, so that's the answer. That's just not how it works. Most judicial officers apply common sense and try to make everything kind of like fit. See, you can take the law as pieces of a puzzle, or the law is the puzzle, but you can kind of make pieces fit sometimes in the puzzle that you want, or how it turns out. And at the very end of this opinion, I remember it said something about the issue here was not the coronavirus caused property damage. The issue here was there was less income or reduction in the number of people traveling, or it wasn't the property being damaged, okay? It was these other issues that caused the losses, the financial loss, not the property causing a financial loss, not the COVID sitting on, like you said, like gum on the floor or something like that. It's just people weren't traveling. People weren't using the services, okay? There's also this opinion talked about even more specific things. If people have tried to make all types of creative arguments about, well, the property is damaged because it requires it to be cleaned in order to use it, and so we should get like coverage because cleaning implies something's damaged, maybe. But they said no, you can't do that. But basically, it's the loss of income from people not using the services. It's not that the property was inoperative because it was damaged, Anyway, that's how I look at it.
And I'm just going to the next slide. Just
Hey, Neil, can I chime in here?
And absolutely, Michael. Absolutely, Monty. I just want to let people know I've got another slide up. Read some of the things. There were some just what I thought were some interesting points about the case, but go ahead and give us your opinion about the opinion.
Yeah, I agree with Michael. I think the Supremes came to the right conclusion. I remember when all those lawsuits were filed during COVID, and I started seeing those newspaper stories. I've done enough insurance cases, primarily bad faith, over my career, but I remember thinking about that and thinking, okay, in the insurance contract, the contract defines the coverage. And all these commercial properties require property damage. And that was the problem, I thought, from the very beginning that the claimants were going to have. You really don't have property damage with a virus. And that's ultimately what the Supreme Court decided. Now, the Court of Appeals have come to some different conclusions, but you get coverage because there's property damage. And while property damage often leads to closing of the business or having to repair it or all that, because it was a different thing that created the closure, not property damage, no coverage. So I think they got it right. And I wasn't surprised that they came to that conclusion.
So just a couple of things while we're on this slide. You know what, Monty, I agree with both you and Michael here, and it's nice to have some clarity. I just thought it was kind of interesting when you see who's supporting which parties in any particular case. And who is supporting Planet? Well, California Pizza Kitchen, the infamous French Laundry, and then two of the biggest band of Indians, that operate casinos. in California. Interesting enough, who was representing Vigilant as an amicus? California Fair Plan chimed in, which I thought was very interesting. And then there's two briefs that did not indicate that they were supporting one side or the other. And I write a lot of amicus briefs in my job at CAR. And we always indicate who we support. And I remember one time we wrote a brief where we really were just wanting to let the court know what we thought were the applicable principles. And we really were not trying to side with one side or the other. And the court rejected our brief, even though the rules of court allow you to write an amicus without necessarily supporting one side. The court rejected our brief and said, no, you have to tell us which side you are supporting. And so nominally, our brief, I guess, could have kind of been in support of one of the parties. So we rewrote our introduction, but didn't really change our brief. So, but you rarely see something where a party is not affirmatively supporting one side or the other. My favorite item, though, had to be footnote 8. Another planet alleges that the COVID-19 virus damages air by changing its composition and rendering it harmful to humans. But alas, it acknowledged in its briefing that the insured does not own the air. I love that. Thank you for the court for pointing that out. So let's
we have another
move
case.
on.
We have another case today, the one about the corgi dog. That lawyer made another interesting argument, a couple interesting arguments too that didn't work out.
Yeah, so today's a great day. I'm glad we got a bunch of people with us today, and let's see what our next case is. An interpretation case. So we're going to stick to insurance. Now we're back to the lower level, the California Court of Appeal level, right? The second district. And what happened here? Well, there was a commercial general liability insurance policy. Okay, California Specialty was hired to install duct insulation as part of a larger project. Okay, air control was, I guess, must have been the general contractor here. So an air control employee was injured, while a California Specialty employee drove a scissor lift into a ladder into which the air control employee was standing. Of course, he fell, or she fell, and was, seriously injured. So the air control employee sued Commercial Specialty for negligence. All right, makes sense. The Commercial Specialty employee ran into the ladder. Commercial Specialty tendered to its insurance carrier. The policy had an exclusion for bodily injury to the employees of any contractor, So Allied says, well, wait a minute. The employee was an employee of Allied. Allied is a contractor. CS, you have an exclusion if the employee of any contractor is injured. We're denying coverage, right? So there was cross motions for summary judgment. The trial court said, oh, the term contractor as used in this policy is ambiguous. We are going to interpret that ambiguity in favor of the insured, saying that the exception would only apply if one of California Specialty's employees was injured. And we could talk about why shortly. And Allied said, no, that's ridiculous. It uses the word any contractor, and therefore the exception should apply in this case. Case went up to the Court of Appeal. Court of Appeal said, let's look at this. We're looking at bodily injury, employee or temporary workers. It's kind of trying to figure out how to use those, how they should be defined. And basically it came down to what? It came down to coverage provisions are broadly construed, right, in favor of the insured, and exclusions are narrowly construed. And the appellate court said, yes, Allied is focusing on the word any, but what they should have been focusing is on the word contractor. and what does the word contractor mean in the context of this insurance policy. And so the decision was upheld. There was coverage, right? I think when we look at the general rules of interpretation of insurance contractors, general rules of interpreting insurance policies, that makes sense. But maybe I'm a little outside of my area here. So Michael or Monty, what do you have to say about it?
Um, so thinking about this case, I could see how it could be flipped, and the court could have found the exclusion, but the court followed traditional insurance contract interpretation rules, like you said, and then the broader way. And this particular insurance contract and this particular insurance company, when they drafted it, they failed to define contractor. And that word contractor is important in the context of that exclusion. I mean, it's a type of word or phrase that typically would be, I think, defined inside of the contract, and they didn't do that. And then courts looking at the big picture, this is an injury. Insurance is designed to protect the property owners, through insurance for injuries. A lot of people fall off ladders. It's a common thing. So they wanted to find coverage. So I see it's a proper decision, but I was thinking, I see the intent of the exclusion, like how far down the line do we let, people make claims as opposed to shifting the burden of the insurance to the say the contractor himself. You know how the general law is you have to have workers' comp insurance if you're a contractor, and but back to that public policy, it goes up the chain to the property owner. If the property owner hires a contractor who doesn't happen to have insurance or doesn't happen to have workers' compensation insurance, the property owner is going to end up being liable. So then it goes back to the first thing. Well, this provides coverage for the injured person. So I see the decision. I'm okay with it. So anyway, that's what I think. I don't know what Monty thinks.
Well, I think the Court of Appeal got it right. I mean, the plaintiff in the case was trying to get coverage, which the carrier had denied. And, I think the court properly said, look, when you're trying to interpret a claim or a policy term or an exclusion, it's ambiguous if it's capable of two or more conclusions or constructions, both of which are reasonable. And the court said, yeah, you've got two possible constructions. The carrier was trying to say contractor means any contractor, whether it's the general, whether it's a sub, whatever. And, the plaintiff was saying, no, it has to be a contractor that we've hired. And we didn't hire the general contractor because the property owner hired them. So therefore, that's a reasonable construction. And if it's ambiguous, you're going to probably construe it against the drafter, which is the carrier. So if the carrier wants to get more teeth into an exclusion, and this happens all the time, if something happens, an exclusion is found to be not clear enough, you can bet in the future the carrier will probably revise the policy and try to make better definitions. And under the circumstance of this case, I think it made good sense. I mean, you've got a policyholder who's trying to buy protection and they were being denied protection. And if you do have an ambiguous exclusionary term, it's going to be construed pretty strictly and probably not in favor of the carrier. And that's what the court did, which is pretty common construction in these kinds of coverage issues.
So I know when I first read this case, my initial take was I agreed with Allied. I thought the court had it wrong. Excuse me. Sorry about this. Try and get rid of this call. Not doing too good at that. Hopefully it'll hang up soon. Because I was thinking, it says employee of any contractor. They didn't say the employee of the insured, right? They said employee of any contractor. So I was really in the line of interpretation, looking at it the same way that Allied Insurance did. But as I reread the case, I thought, you know what? I can understand that there's a different way to interpret, and maybe the court was right, Monty, that both ways to look at that phrase were reasonable ways to look at it. So my initial take was not unreasonable, but neither is the other way to look at it. And as both of you said, the court applied really just general contract, insurance contract principles and reached its decision.
And the plaintiff in this case admitted that the construction by the carrier was a reasonable construction, and that's true. But that doesn't mean the issue is over. The question was the plaintiff's construction also a reasonable construction? And I agree that I think it was.
And like I say, after rereading it, I came to that same conclusion. So, Monty, we're going to talk a little bit more about how you come to your conclusions, because now we're on the interview portion of our segment. And I want you to tell us, a little bit about your practice. Michael may have some specific questions for you, but why don't you introduce yourself first?
Well, thanks for having me as a guest. It's delightful to be here. I've been a California lawyer for a couple of years, since December of 1980, and most of my life I've been a civil trial lawyer, tried a lot of jury trials, judge trials, arbitrations, other things, pretty broad, plaintiff defense, business insurance, real property torts. So I like variety. And the last really kind of 10 plus years, I've been primarily doing ADR work as a mediator and arbitrator and referee, and I do that with ADR services while I'm in San Diego, as far as where I have my office and reside. With Zoom, I could do things throughout the state. And as we went into the pandemic, everything changed in the mediation approach of things, where usually before the pandemic, everything was all in person. But since we've been locked down and then released from lockdown, still a vast majority of people like to do mediations online. I found it to be a very useful tool, settle lots of cases. So happy to help folks, and it's easy to do it throughout the state that way. So I do that work. As you guys have seen in the real property section, I also summarize civil cases that are published in California, and I've been doing that for, about 10 years. And I've always been pretty good at being able to simplify things, and that's something I can do and help me in my trial work, helps me in my ADR work. But I wanted to keep track of things because I have a broad interest, and so I like to prepare these one-paragraph summaries, and you see them in the real property section once a month. But I do them for all the cases, and so it's just interesting for me, but I think it helps me be a better mediator, arbitrator, and referee. And then I sell subscriptions to lawyers and law firms under my publication called California Case Summaries. So that's something I do. And I also, a year ago, started a podcast I call Trial Alchemy. I've been a member of the American Board of Trial Advocates since 1995, so it's been a long time. And back in those days, you had to have tried 20 case jury trials to conclusion to be even qualified to be considered. And they had to consider you to be an excellent trial lawyer and somebody who is professional and follows the rules, and you're not a jerk, in effect. And I've been honored to be part of that. But so what I do in the Trial Alchemy is I do 1-hour interviews on my podcast of some of the best plaintiff and defense lawyers throughout the country. I've been doing more California lawyers to start with, but I've interviewed people in other parts of the country, Mississippi and Arkansas. So it's fun to do that. And that podcast can help lawyers, whether they've tried no cases, one case, or lots of cases, get ideas from other practitioners who really are trial experts. So I like to do a variety of things. I'm keeping happily busy with those kinds of things, and being a grandpa these days to my first grandchild, who's about 18 months old. So those are some of the things I'm doing right now.
So Monty, for those who haven't paid attention, Michael just posted in the chat tab a link to your podcast. So those who are interested, can, cut and paste that link and hopefully listen. Now, we said, and you mentioned that for the real property e-news, we just get a short blurb from your summaries. Do you do that for any other sections of the California Lawyers Association?
Nope, not at present. I mean, I talked with folks a while ago at the real property section, and there's always tends to be a few real property cases every month, and I publish my case summaries monthly, quarterly, and annually. And so, yeah, I'm happy to provide that to the real property, but nobody else in the CLA is asking for those at present, but I've been happy to provide it for this section.
Right, yeah, and we are too. And you go well beyond just real property. You address all civil cases. Michael, did you have something you want to ask Monty?
Well, that's another benefit of joining the real property law section is you can get access to the e-news with Monty's commentaries on the new cases. You remind me, I used to buy Roger Bernhardt used to do little summaries of real property cases. I used to buy his book every year, and then unfortunately it stopped for different reasons. But maybe you can assemble an annual book. I mean, I still like books. I'm old-fashioned.
Well, actually, you could any subscriber would get monthly summaries and then quarterly summaries with the official case citations, and then I prepare an annual issue. So the annual issue has all the cases published in California the prior year. But, if your practice is real property, you'll know all the real property cases because you'll get it. So it's a pretty good value for the subscriber.
And how much is it? I mean, how much
Well,
does it
a
cost?
subscriber can pay monthly for like $199 a month, so it's less than a billable hour per month, or they can pay annually, and I'm trying to remember. I think it's $1,099 per year, which saves you about 300 plus bucks. And with that, you're always going to know the new cases in your practice areas. Now, a lot of people may have more than one practice area, but even in real estate, for example, and today is a good example of that. With real estate, you're going to have insurance issues. And so you probably want to keep up with insurance cases, just like we saw with the Supreme Court. All those coverage issues with COVID, we're dealing with property damage in commercial liability cases. That's going to be a concern of somebody who has a real property practice whose clients are dealing with those spaces. So there's a lot of things, like most lawyers who do civil litigation should probably read every civil procedure case and probably every civil code case. And there are a fair amount of civil procedures every month. They should probably read every evidence case. Not as many evidence cases get published each year, not with civil cases. And, a lot of people should know insurance, whatever their practice area is. But, if you're an employment lawyer, you want to know employment. If you are a tort lawyer, you want to know tort. And so my subscribers, I do everything by legal topic. So you get a monthly issue, you can look at the section that deals with your areas, and very quickly what you need to know, what's important in your practice areas. So you always look smart, get a competitive advantage, helps people win cases. I've had testimonials from people telling me that. So it's great. I'm glad to help folks. And I find it intellectually interesting to keep up with it.
And so what percentage of your practice is, you mentioned you're on the ADR services for mediations. There's mediations. You also do arbitrations.
Most of my work generally is mediations, but depending upon what happens with a mediation, it's usually a full day, half day thing, or however many hours you spend. But when you do arbitrations, a lot of arbitrations settle, but when they go to hearing, that can be a lot of time because it may be 5-6 days longer of hearing. So while most of the time I'm doing mediations, most of the time kind of varies depending upon do I have arbitrations that are going to hearing? And in those cases, there's a lot of hours involved with that. But I enjoy both of those. And the thing I probably do the least amount, but I enjoy that, is when I get a reference case and get some issues that may be interesting, trying to decide and deal with counsel.
Like on a partition action to be a referee in that? Or that's usually like a real estate agent, or what type of reference? Discovery?
A lot of times it's discovery, but yeah, I could be a referee in a partition action. Exactly. So you could do that. But a lot of times with the discovery referee, I'll do, let's say people have a dispute and the court is tired of dealing with their discovery disputes. And if I get appointed as a referee, I'll just have this process where if somebody has an issue, I say, let me know appropriately. Let's have an online telephonic conference. You can informally tell me what your issue is, what your position is. The other side can tell me what their position is without having briefing or formal argument. I'll give you my informal impression. And if that resolves it, great.
Kind of like an informal discovery conference with a court.
Yeah, I'd like to try to give them an opportunity to resolve it informally. And if they can, great. We don't need to go do the formal hearing. But if they can't, well, I'll set a briefing schedule, we'll have a hearing, and I'll make a decision or recommendation to the judge.
What do you think is the one most important thing people must keep in mind when they're doing a mediation?
Well, I think they need to keep in mind the unpredictability of any trial. And the fact that with a jury trial, you're going to have 12 judges, and even with a judge trial with one judge. What I see often, and probably very commonly in mediations, is both the clients, and they've usually never been through litigation, but both the clients and the lawyers tend to vastly overestimate their strengths and vastly underestimate their risks. And that's one of the things that I think I can provide with my 44 years of trial experience, is I'm just a truth teller in each of the rooms saying, here's some realistic ways that a jury or a judge may look at this very differently from your position. And that's a risk factor for you guys. And
well, lawyers tend to drink their own Kool-Aid and they get blinders on and they don't pay attention. So you can step in as essentially like an expert lawyer witness, say an expert, and say,
right.
I'm not so sure, maybe you ought to consider something else, especially with the wealth of substantive knowledge that you have by you continuing for the last 44 years as a law review editor.
Well, lawyers, maybe they don't start out in their cases with blinders on, but I think a natural things that happens for anybody in litigation is you're trying to think about your case and you're focused on the strengths of your case. And as they do that, yeah, they become so entrenched in their story and ingrained, they lose that objectivity. And so it's helpful to have somebody who has no stake in the game, somebody who gives some independent feedback, who has got a lot of experience and can give them some things to think about. Because yeah, lawyers do get those blinders on. And I think it's pretty natural, just being an advocate. You're going to get more and more ingrained in that tunnel view of this is the way we're going to show our case.
So Monty, I think you're right. I think actually the two cases we just discussed are perfect examples of that, right? The one insurance case where there was two reasonable interpretations of the same word, right? And you could see, I don't know if it happened here, but you could see where maybe each side was entrenched in their belief that their interpretation was right, and the other interpretation, that's just hogwash. Who would believe that?
Right.
But objectively, they could both be reasonably, and that is the risk. Monty, I'm going to have us move on, but before we do, if somebody is interested in contacting you about your service, we've got your email up on the slide right now. Is that the best way to contact you?
Yeah, if somebody wants to contact me, they could email me at my email address or give me a call on the phone number. That'd be great.
Okay, wonderful. Good. Thank you, Monty. And
Thank
we're
you,
looking
guys.
forward to some more of your commentary as we move on. which we're going to do now. So we're going to talk about another injury case. This one, Helm versus Los Angeles. Someone went to take their dog down to the beach and tripped over a wire that was running across between two posts, actually pretty low posts. Those posts are pretty low. I can't remember how high they were, but they're only like 24 inches high or something like that. And the purpose of the wire or the cord, the cable that was stretched across was to prevent vehicles from coming in and out of a location that was designed for humans, right? Designed for humans and their pets, and so that they would not be endangered by vehicles, but there was this cable running across in case repairs needed to be made or there were some emergency situations and the like. So this person parked the car, took his corgis, down to the beach, let him go
I
play in
love
the
the
water.
corgi.
Yep, yep. And the corgi went right under the wire, and
But look at
the
his legs.
individual.
He's not jumping over the wire.
Right. Yeah.
So Neil, the corgi went right under the wire, but the owner didn't.
The owner didn't, right? That's the way to say it. So, of course, the owner was injured, and what did the owner do? The owner does what all injured peoples do, sue. Okay, so I have no idea whether the owner was seriously injured, whether it was a moderate injury. We don't have that information. I didn't notice it in the case, but brought a suit. The government entities. It's interesting here. There's both the counties of Inyo and Los Angeles. So I'm not exactly sure how the ownership of Diaz Lake works, as well as the city of LA, but they said we've got government immunity. Well, the owner said, well, wait a minute, this is a dangerous condition, and there may be government immunity for trails, but I did not get injured on the trail. I got injured because of this cable that was leading to the trail. So that government immunity should not apply. Let's just look at whether this is a dangerous condition. And the appellate court, looked at that, and I'll kind of summarize for me what the appellate court said was, well, wait a minute. You really did not distinguish, you, the owner of the dog. You really did not distinguish. You just figured this was all part of the trail. It may be the entrance to the trail, but it's still part of the trail. And because of that, the governmental immunity applied. Okay. So, not good for the injured party. Good, I guess for the taxpayers in LA City and LA County, and in Inyo County. But one of the things I found most interesting about this case is actually on your screen. And it's that top picture, and it's hard to see. You can see the post. It's very hard to see the cable running between the post. But this picture was actually in the opinion. And I've noticed in some other opinions, I've started to see some graphics in other opinions, right? So maybe the courts are realizing what trial attorneys realize, that you can only accomplish so much with language, but a picture paints 1,000 words. And to me, it was fascinating that the court put this picture into the body of the opinion. And it's something I think we're going to see a lot more of. As courts get more sophisticated, they're able to figure out how to do this, how to make it work, how to get all of this stuff, published. It's not necessarily right in a book anymore. You do all your research online. So I think we can expect to see more opinions that have graphics in them that are describing the situation so that attorneys representing other parties in the future can then evaluate, right? Is my case similar or is my case different? Rather than just looking at words, looking at pictures to help them make an evaluation for their client. Mike, what do you say?
Well, I'm glad you pointed out about the picture. I don't know for how many years, but at least since I started to own Adobe Acrobat, I tend to copy and paste snippets of contract clauses, pictures. I've always done that in my briefs, always done that. And my associate always says, why do that? It takes up space. We can make everything like half a page shorter. No, the picture, and also it prevents the judicial officer from having to say, turn to the exhibit. They see exactly the paragraph and the language at issue, along with the statute above it. And you can say it's missing the element because, the contract doesn't say it. So I love pictures and snippets of contracts. That's an amazingly important part that you have to use in your briefs. And in these court, I forgot what they called that. Remember the one where they had the part near the river, and it was the thing that stuck out of the river, it had like a word with a P in it or something. I just I just love that. But let's talk about the corgi. This is what I think. There's a game where you play cards, and what did he say? I call that bullshit. I think the court basically did that here. So I'm reading what this guy did, and I don't understand. There's one part here about this corgi with 4-inch long legs, and he says that it was walking towards a wooden post in the cable with his dog, and his dog was 6 inches in front of him. How can you walk with a leash with a dog 6 inches in front of you? You're going to step on the dog, right? Okay, that makes no sense. And then in the picture, you can see there's nothing. This isn't like obstructed by vegetation. I could see if there was the wire and it goes off and there's like vines on it and you can't really see it. This is like way out in the open, It's pretty obvious. But with this dog walking 6 inches in front of him, and then he said Mr. Helm was looking at the lake and not at the ground when he approached the wooden post and the cable. How do you walk? I mean, it's so comparative negligence beyond. It's 99.9% liability, even if he survived this. But then there's our civil procedure part here that the court pointed out. The guy is bringing up on appeal things that, he didn't point out what are these triable issues of fact. His briefs are terrible, terrible. And then the other thing that was kind of funny is they made it really clear. Apparently he had some expert, and I see this a lot. A lot of people think, oh, I just hire the expert, I pay him whatever, $3,500, $5,000. It gives me something. That's all I need to create a disputed issue of fact to avoid a summary judgment motion. But the problem is nobody reads what the expert's declaration says, because you need to take that expert's information, give him correct information, read what he gives you back. Don't just copy and paste it. And here, I think the guy copied and pasted something because it said in the Court of Appeal opinion, nor can Helm create a disputed issue of material fact by simply referring to, and this is the key, without any explanation or analysis, that's like ChatGPT work, without any explanation or analysis, his expert's declarations in which he refers to the area where Helm tripped and fell as a parking lot. Okay, parking lot. Okay, and he just said that what the expert said apparently had nothing to do with what his own deposition testimony was. And this appellate opinion has a lot of snippets also from Helm's own words, from depositions and all, what happened. And so you can't just hire the expert to say that's going to save me and create a triable issue of fact. That's all.
So Michael, we've seen that before where courts, I guess, are just frustrated with bad lawyering, because we've seen other opinions where they go out of their way to point those things out, things that they don't have to raise. They could have made their decision, just focused on, Government Code 83.1.4 and let it be. But they want everybody to know if somebody hasn't done their job. And we've seen other opinions where appellate courts really are not shy about doing that now.
Yeah.
Monty, quickly, and then we'll go on to our last case.
Yeah, so I agree with Michael on the issue of you see this picture in this opinion, and there's tons of open space on both sides of these little pieces of wood. And even if he was able to beat the trail immunity, which he wasn't going to, you'd have to think, well, jury's going to be going, what the hell? Why don't you walk around it with your little corgi? and why did you walk through it? So it's not, it's a case with all kinds of problems for the plaintiff, and there's a big possibility of a defense verdict, even if you got to trial, or a substantial comparative fault. But this is another example of the trap for the unwary of suing government entities, because a lot of plaintiffs' lawyers, if you haven't dealt with tort claims or other things against governmental entities, there's all kinds of immunities. And so this trail immunity is something that can come up all the time. And there's a recreational immunity as well in California statute. So I can remember, heck, one of the first cases I worked on as a young lawyer in the early 80s was a guy was at Black's Beach in San Diego, sunbathing. He was probably nude because it was a nude beach, and the cliff fell down, and he was too close to the cliff, and it killed him. That was covered by the recreational immunity. So anytime a plaintiff is thinking about suing a government entity for a tort, you better find out about the immunities that apply, and you better figure out if there's a way you can get around the immunity so it won't kill your case. And that's what this immunity did, and it does it all the time.
So both of you, I'm going on to our next case. While I'm changing the slide, I want to say I think the plaintiff missed an opportunity. The plaintiff should have said that they were completely mesmerized by the natural beauty of Diaz Lake. And because of that, they just, could not have paid attention to these obstacles because of that natural beauty. But anyway, let's move on to simple AVO versus Southern California Edison. Here, case arose out of the 2017 Thomas fire in Ventura and Santa Barbara County. As a result of that, this owner of an avocado farm was alleging inverse condemnation because of all the damage that was done, allegedly because that the wiring, the SCE wiring, was the ultimate cause, or was the initial cause of those fires. Entered into a settlement agreement with SCE. The settlement agreement says it is appealable. Okay, so, and great. So they said that by stipulation. The appellate court, one of the issues was, well, can you really, by stipulation, agree that a settlement is appealable? And the appellate court, with a lot of reservations, said, yeah, we think so. What started off as a very narrow exception has been gradually broadened by courts of appeal throughout the state. And as we see in that last statement on the screen, the courts of appeal have been unable to craft reasonable limits on this ability for parties to create their own right of appeal in a stipulated judgment. The court says, we discourage these side bets, but we think we're kind of bound by precedent in California, and we have to allow this right of appeal. So I'm not even going into the substance. To me, that was like the big issue here. And I'll turn it over to the two of you. Let's see if we can kind of wrap it up in maybe 2 or 3 minutes so we can address our last issue.
Well, just real quickly for me, I believe the precedent here has been the California Supreme Court has allowed stipulated judgments. They clearly carve out that the matter can be appealable. And I think that this appellate court is saying we're so overwhelmed on our docket with so many appeals that have not settled the underlying case that people just want basically a declaratory relief opinion or judgment about something, that's a waste of our time, and they want the Supreme Court to change how things are going, or a statute to be changed, and they want to change the precedent. I guess they can try, but I think that there's actually a lot of benefit to having at least certain types of cases. Maybe it's limited to what you could do the stipulated judgment with the right to appeal for what types of issues, but I hope they don't change that, because I've been involved in some cases that had stipulated judgments and an appeal followed.
Monte, what do you say? I'm not a litigator, so this is all outside of my realm here.
Well, as far as the Court of Appeal concerns, I understand their concerns, but they felt they had to do it. But if you think about it from the standpoint of the use of court resources, I think the concept of saying if the parties do a stipulated judgment or a settlement and that allows an appeal, that actually is a pretty cost-efficient way to reduce the amount of court resources that are required to be used, because otherwise you'd have to go through the whole trial of a case and get to the point where you could appeal, and you're using a lot more resources to do that. So I think it makes some sense, and it was something where you could get a Court of Appeal ruling on this issue of inverse condemnation, and that's going to be useful in all these other fire cases that are related to the same issue. So I think it makes some good sense.
Except for that they pointed out, people always cherry pick the plaintiff for the appeal because
Yeah.
you need good facts or you get a crappy law generated on appeal.
Yep.
Yeah, and that clearly was the Court of Appeals concern here, that SCE cherry picked. They entered into lots and lots of settlements with lots and lots of principles, and the one that really wasn't involved in the underlying issues, that wasn't fighting those issues, right? This is the one that they're going to allow for appeal because this, I'm assuming from SCE's standpoint, they're figuring this is the one that's going to present the weakest substantive case for us when we get to the appeal. But I guess that's just the nature of it. There are pluses that the both of you have just described, and there are potential detriments as well, and that's one of those potential detriments. Okay. All right. Well, let's move on. I just want to mention a case here to you. It's Redondo Beach versus Bonta. It deals with SB 9, which was passed a couple of years ago in California, that basically it did away essentially with single family zoning in most parts of California. You could build 2 units on a lot. You could split a lot into roughly equivalent separate parcels. So theoretically, you can now have 4 units on a lot. What happened? There were 5 cities that were challenging SB 9. And the trial court said, well, SB 9, in the statement of intent, the purpose was to create affordable housing. There's no evidence that SB 9 is any help at all in creating affordable housing. SB 9 may help in the creation of housing, but not necessarily affordable housing. And how did the court look at affordable housing? How did it define affordable housing? Well, basically, you're talking about low housing for lower income parties, right? So yeah, you can split a lot in Beverly Hills. That does not mean that either of those two new properties are going to be affordable, right, for low income. So the court took a very narrow interpretation of what affordable housing meant and looked to the statement of legislative history behind SB 9 to reach that. Well, we just heard, it says there this past Friday, the Attorney General has filed a notice of appeal of the Superior Court decision. The Attorney General says, well, wait a minute, SB 9 should apply throughout the entire state. You should not have 5 carve-out cities that do not have to apply. I understand the trial court had the possibility of extending its opinion statewide. It declined to do so. So now there's these 5 cities. They don't have to comply with SB 9. Now, could the legislature revise SB 9? Could they change the definition of affordable housing? Sure, that's something that may easily be done. But this really is a case to watch, because now what will happen in the appeal will definitely have a statewide effect. It won't be limited to 5 cities. I see the 2 of you kind of nodding. So if you have something you want to say, go ahead.
The only thing I'll say is be careful what you ask for, because this is going to prompt a change. and what is the definition of affordable housing and how that may limit, lot splits and building things may not be what property owners or builders want.
Yeah, affordable housing is a interesting issue because a lot of the policies local governments and stuff employ to try to build affordable housing make it more expensive because they charge the developers more money for the ones that are sold that aren't low income housing to build the low income housing. So I think it's going to be one to watch too, Neil. I think it's a good thing that you brought up.
So, and again, we have some listeners today. If you have a trial court case, it's going up in appeal, you think it's going to be of interest to real property practitioners, I'm not guessing as to which way this is going to go. I'm just saying this one is worthy of keeping an eye out for, because it could have significant impacts throughout the state, no matter which way it gets decided at the appellate level. All right, so we're at our ending time here. What do we always do? We always make sure you're aware of what's coming up at the real property section. So not a lot coming up, immediately. We've got a lot of potential webinars in the works, but we don't have specific dates for them yet. So I just wanted to make you aware of those. All of you listening today will get a copy of today's presentation along with your MCLE credit. And I believe that gets sent out, I think it gets sent out tomorrow. So look for that. And I got what's coming up next month. Can private parties bring civil suits to enforce local ordinance? So that's one of the cases we're going to discuss next month. And some others as we find them, as they get printed, as Monty knows, there's always real property cases every month that wind up getting published. If you have a comment for us, a suggestion for us, a case for us, you want to make a comment for us, great. Reach out to me, Neil K. at car.org, or reach out to Michael at simkinlaw.com. Thank you for joining us today, Monty. I will leave it up to you and Michael to close us out.
Thanks very much for having me here. It's been a pleasure. Really enjoyed it, guys. So thank you.
Well, thank you, Monty. I'm glad you could join us. And if anybody is interested in being on a What's Up With Us episode or helping with real property issues in the state, legal issues, we have positions always on the Real Property Executive Committee. You can apply for that too. It's a lot of fun.
It certainly is. Thank you, everybody. See you next month.